broadcast is now starting. All attendees are in listen-only mode.
Hello, everybody. This is Jennifer Schaus, and I'm joined today with Mark Amadeo. We are going to be discussing joint ventures and government contracting, talking about strategies as well as legal considerations. For everyone that is on the line, if you have any questions throughout the webinar, on the right-hand side of your screen, you should see basically a panel or a box, and you can type in your questions. We'll address those at the end of the webinar and kind of go through those one by one. Additionally, the webinar is being recorded, so if at any time you need to jump off, we will send out the recording after the session is over, probably tomorrow morning. With that, we'll get started and dig into this piece. I've already introduced our speaker. We'll go through the presentation, like I said, and the questions and answers at the end. First, I wanted to thank FedBidSpeed. They are one of our partners here in the webinar series that we're running. FedBidSpeed has a great software program for government contractors. It's more of a, I would call it a CRM system for the B2G community. So if you're pulling in ops or really out of anywhere, you can use their system to manage the opportunity, share it with team members, and kind of assign tasks to write the proposal and then respond to those opportunities. If you have a moment, take a look at their website. It's fedbidspeed.com. I believe they offer a free trial for about 10 days or so. But highly recommended, and it's a good tool dedicated just for the government contracting community. Next up is another partner, Fierce Government. They are a publisher of, I would call it, high-quality IT government newsletters. When you look at some of the other news companies out there putting on or pushing out government information, Fierce Government is definitely the leader. A lot of good quality information. Again, if you get a chance, jump onto their website. It's fiercegovernment.com. As I mentioned earlier, we've got Mark Amadeo. He runs his own law firm focused on local and federal contracting, employee benefits, and employment law. My name, again, is a consulting firm here in Washington, D.C. We're really with GSA schedules and headers with federal sales, marketing, DCAA audits. We also put on government contracting events at the Kennedy Center in Washington. So we will now get started with the joint ventures and government contracting, and I will turn this over to Mark.
Hi, everybody. Glad to be here. As mentioned, my name is Mark Amadeo. I'm an attorney at the Amadeo Law Firm. Our firm has offices in Washington, D.C. and in Frederick, Maryland. And as Jennifer mentioned, our three primary practice areas, and that's contractors, and we handle all aspects of the legal needs that our clients require, teaming agreements, bid protests. So we're here as that term is used in federal contracting. Companies use the first is what I call this is a recognition that that the government will enjoy efficiency and cost savings as opposed to having to contract with companies to perform minute tasks that can be better handled collectively. With regard to small businesses, at the same time, there is a tension which I think is increasing over time, and that is the government has stated goals of awarding a percentage of its prime contracts to small businesses. The current goal is 23%. And there are in place sub-goals for awarding contracts to specific kinds of small businesses, like women-owned small businesses, hub-zone businesses, service-disabled, veteran-owned small businesses. And the one way that the government tries to meet these goals is by setting aside government contracts for the for small businesses that fall in these categories. On the other hand, the government has fiscal concerns, and there is increasingly a concern over saving money and maximizing efficiency. And we see that now in terms of the trend towards contract consolidation, whereas in the past we might have had multiple contracts in a particular procured by a particular agency, handled by different contractors or vendors. Now we're seeing, I think, increasingly over the last several years, a trend towards consolidation. And you see that in particular with IT contracts. So increasingly, despite these contracting goals, I think there is an issue and a concern whether or not small businesses can really handle even small parts of a job or task order. So I look at joint ventures, and I think the rules recognize joint ventures as a way to help ease this tension by allowing small businesses to band together with other small businesses, and in a very limited circumstance to band together with a large business and still compete for these small business contracts or contracts that are set aside for small businesses. Now, there's a general rule under FAR and the government contracting regulations that revenues and the employees of entities that are affiliated are combined for purposes of determining whether an entity is small enough to compete for a small business contract. And there's also another rule that joint venture partners are deemed affiliated. So when a joint venture, it generally applies, competes for a contract, the number of employees or revenues of the joint venture partners are combined to determine whether that joint venture entity is considered a small business for purposes of a small business contract. So, for example, if you've got like a procurement or with a $10 million cap on revenues, if a joint venture applies for that contract, the revenues of the employees are combined. So the joint venture has to be concerned about whether or not their combined revenues fall under the cap for competing for that contract. However, the SBA regulations on joint ventures have an exception to this affiliation rule, this rule that generally requires the parties of a joint venture to have their revenue or employees combined. And that's where I think a lot of small businesses will find opportunities to compete for small business contracts that they otherwise might not consider or might not compete for. It's these relaxed joint venture rules, which have become even more favorable since the SBA regulations were amended a couple of years ago. So as a result of these relaxed rules, we can have small businesses scale up and take advantage of a larger business structure or larger business size and still compete for small business contracts. So let's take a look at some of the exceptions to affiliation. And again, these exceptions will allow a joint venture to be considered small and compete for a small business contract regardless of the collective size of the joint venture parties. So one exception to affiliation is for small businesses that form joint ventures and they compete for bundled contracts. Again, a bundled contract is a contract that was once performed under separate smaller contracts that's been combined into a single larger contract. And what the joint venture rules allow is for small businesses to compete for these bundled contracts. And the two requirements there's one requirement, and that is that each joint venture participant has to be small under the size standard for that small business contract. So getting back to my earlier example, where I mentioned a small business contract with a $10 million cap on a size standard, if you have two small businesses, let's say one that has $7 million in revenue and another with $8 million in revenue, their combined size typically would be too large. It would be $15 million, and they would not be able to compete for a small business contract with the $10 million size cap. But under this exception, these two businesses are now able to compete for a small business contract that they otherwise would not be eligible for. Another affiliation exception applies to what I call 8A joint ventures, and that is contracts that are set aside for businesses in the SBA's 8A. And here, the contract size has to be at least a certain amount. It has to be at least a certain amount, depending on how the small business cap is set. Now, the requirement for to compete for those contracts is that each joint venture must be small. Each joint venture partner must be small. Only one has to be an 8A certified company, and at least one of the 8A partners has to be really small. And by really small, it has to be less than half of the size standard that's set for that small business contract. Assuming all those requirements are met, then the joint venture can compete for an 8A set-aside contract. Another exception to the affiliation rule is for a joint venture that's comprised of participants in the SBA's 8A Mentor Protege program. And in this case, an 8A Mentor Protege joint venture can apply to any contract that has a small business requirement, including an 8A contract. And the requirements there are that the mentor and the protege have been approved, they're in the 8A Mentor Protege program, and the 8A protege has to meet whatever the size standard is set for that contract. I think the 8A mentor-protege joint venture exception to affiliation is pretty remarkable because a mentor can be of any size. I mean, you can have a large business mentor to an 8A protege. And this is one of the rare instances, I think, maybe the only instance that I know of, where a large business can actually compete for a small business contract. So this exception, I think, is fairly unique. Now, there are, let me just see here. Okay. There are other exceptions to affiliation that apply to other kinds of joint ventures, like hub zone joint ventures or joint venture that's comprised of hub zone entities, or service-disabled joint ventures, which would be a joint venture that's comprised of at least one service-disabled veteran-owned small business. And while we don't have time to get into the specific requirements for those kinds of joint ventures, these joint ventures also are examples of instances where companies that can be collectively compete for small business contracts, even though their collective size might exceed the size standard for the small business. So there are at least two other exceptions to affiliation that are recognized under the government contracting rules. So we have these exceptions to affiliation in which the government says, even though you're acting as a business unit, as a joint venture, we're not going to aggregate your revenues or your employees. Now, joint ventures typically are supposed to be for a specific purpose and limited duration. So there's a concern there that if the same companies joint venture together over and over again, and all they do is work on government contracts together, at some point there's a concern that these joint venture parties really are acting as one business entity. And the government takes the position that if that happens, these joint venture partners that collectively act together over and over again, they should be treated like one business, and their sizes should be combined. So the rules with regard to this exception to affiliation for joint ventures, it places a limit on the number of small business contracts that can be awarded to a joint venture. And I quoted the rule in the slide there, but basically, essentially what it means is that for the exception to affiliation to apply, a joint venture cannot be awarded more than 3 contracts in any 2-year period. The interesting thing about this limitation is that the rules don't place a limit on the number of joint ventures that 2 companies can form. And in fact, the regulations and the comments to the regulations, the SBA has acknowledged this. They acknowledge that there is no limit to the number of joint ventures 2 companies can form. On the other hand, the comments to the regulations and the SBA has said they will look at instances where companies are serially contracting together as joint ventures, and they'll look at the facts and circumstances to determine if the exception to affiliation should continue to apply. So while the SBA hasn't really set out what factors and circumstances they're actually going to focus in on, I think that's a concern, or should be, for companies that serially combine together and compete for contracts as joint venture partners. So we looked at one benefit, lax joint venture rules, which allows partners to compete for small businesses when their sizes might otherwise prohibit them from competing for small business contracts. The second benefit is that the relaxed joint venture rules allow businesses to compete for contracts that they simply would not be eligible for outside of the joint venture structure. Now, earlier we looked at the exception to affiliation that applies to 8A joint venture, an 8A joint venture. And we said that the affiliation is relaxed for larger contracts. Well, you can an 8A joint venture that's comprised of at least one 8A partner, even in instances where the affiliation rules are not relaxed, and those are instances where they're competing for smaller contracts, you can still have an 8A joint venture compete for a smaller contract, even if the affiliation exception doesn't apply. And in that instance, the requirements are that, first of all, the contract has to be an 8A set-aside contract, and each joint venture must be small. You must have at least one joint venture company that's an 8A business, and at least one of those 8A businesses has to be really, really small. In that instance, that's an example where you can still have companies that are not eligible for an 8A contract. Non-8A companies compete for an 8A set-aside contract. So even in instances where affiliation is not necessarily applicable, there's still a benefit to the joint venture parties, because you can have you can have companies that ordinarily simply are not qualified for a contract still work together and compete for an 8A contract. Similarly, you have the same benefits for women-owned small business joint ventures that compete for smaller contracts, and service-disabled joint ventures that compete for small contracts. For a women-owned small business joint venture that meets the requirements, you can have non-women-owned small businesses that are part of this joint venture compete for contracts that are specifically, typically geared and set aside for women-owned small businesses. Similarly, with service-disabled joint ventures, if the contract is small enough, you can have this structure that's composed of non-service disabled veteran-owned small businesses compete for that contract. So these are opportunities for businesses, small businesses, to compete for contracts that they simply would never be eligible for to compete for outside of this kind of joint venture structure. We talked a little bit about the 8A joint ventures and 8A set-aside. There are specific additional requirements that joint ventures have to meet when they are competing for 8A set-aside contracts. And the 8A program, as many of you already know, is a very special program. And the SBA is concerned about protecting the integrity of the program. So it imposes certain additional requirements whenever a joint venture competes for an 8A set-aside. First, the SBA has to approve the joint venture agreement before any contract is awarded. And then there are additional requirements for in terms of what the in terms of work sharing. If an 8A is joint venture is populated, and by populated, that term typically means the joint venture has its own parties. The work done by the employees of the joint venture, the 8A partners have to show that they're going to gain from the performance of that contract. And that makes sense because the 8A program is a business development program for 8A businesses. So the SBA wants to make sure that the 8A company is benefiting from that contract. If it's an unpopulated joint venture, and unpopulated means that the work is going to be performed by the employees of the joint venture partners. In other words, the joint venture itself doesn't have employees. It's the employees of the partners that are going to be doing the work. Then there's a requirement, and that is that the 8A partners must perform at least 40% of the work. And the SBA has made it clear that this has to be real work. It can't be ministerial or administrative work. The 8A partners have to get a good share of the real work that's being done by the joint venture under the contract. So there are certain requirements that that parties will have to be mindful of when they compete for, and if they're awarded an 8A contract. Now, joint venture agreements, there are certain the government contracting rules require that joint venture agreements contain very specific provisions. And this is different. So if you have a joint venture for other purposes, you have to be mindful that there are very specific requirements under FAR and under the applicable SBA rules that require that these joint venture agreements contain very specific provisions. So for example, a joint venture agreement to perform an 8A contract has to state the purpose. It has to designate an 8A participant as a managing venture and an employee of that 8A participant as a project manager. And here, there are a couple of cases recently in which the SBA has said, it's not enough simply to name a position, let's say, in your joint venture agreement. It's not enough to name the position within a company as the project manager. You actually have to specify the name of the person. Parties have to be really mindful of these what I think can be nuanced requirements. And then there are other requirements. You have to specify the responsibilities regarding contract performance. All the parties have to state in the contract or in the agreement that they are all responsible for getting the work done despite the withdrawal of any party. And then there are certain additional requirements on maintaining records. Generally, the managing venture, which is the 8A participant, has to be responsible for managing the paper. And then there are some additional quarterly requirements in terms of financial statements that have to be submitted to the SBA. So when parties are thinking about entering into a joint venture, they should be mindful that their agreements from the very beginning have to have very specific provisions and sometimes they're somewhat nuanced provisions. The requirements for other joint ventures are very similar. Services. We haven't I haven't laid them out here, but the provisions for service-disabled veteran-owned small business joint ventures, for example, have very similar requirements in terms of the managing venture having to be, let's say, the service-disabled veteran-owned small business. The service-disabled veteran-owned small business has to be the project manager. I mean, they're very similar requirements for both service-disabled veteran-owned small businesses and for women-owned small businesses. All of this is to say that when you are, competing for contracts that are set aside for certain categories of businesses, and you're competing as a joint venture, you have to make sure that your agreements allow you to be eligible for the contracts that you're competing for. Because the worst thing that could happen is you spend all this time and effort and competing for a contract only to find out later, either during the bid process or afterwards, through a bid protest, that your agreements were not compliant and you were not an eligible business to begin with. So in closing, what I would say is I think there may have been at one time a notion that joint ventures are very exotic kind of arrangements, that they're unusual. And what I would say is the FAR rules and SBA rules, which are very non-exotic rules, they specifically recognize joint ventures as an eligible and desirable way to compete for government contracts. If in terms of how to set these arrangements up, you have to be careful that all of your agreements are consistent and they're all compliant with the joint venture rules. So if your teaming agreement identifies somebody who's going to be the managing party under the contract, it should be consistent with the SBA rules on who has to be the managing entity. So rule one, make sure that all of your agreements are consistent and that they're compliant with the applicable rules that apply to the joint venture that you're entering into and the contracts that you're competing for. You should also be mindful that at some point these joint venture agreements and structures have to be disclosed to the agency, and typically you want to disclose them at the outset when you're competing for the contract. Parties should be mindful of the accounting rules, how to allocate their costs, and then my final thought is, especially now, companies and small businesses in particular have to be very persistent. I mean, some of these rules may be kind of nitpicky, but they're nitpicky for everybody. And the aggressive, ambitious contractors are the ones that are going to, they're going to work through those requirements in order to put together the kinds of relationships that they need in order to successfully compete for and perform under contract. So be creative and be persistent. The last is choose your partners wisely. We looked at some of these requirements will require that at least one entity give up control, right? For an 8A joint venture, it's the 8A party that has to be the managing entity. In some instances, you might have to give up a majority ownership in the joint venture entity. And as we saw, there are work sharing requirements. So parties really have to be careful about who they're aligning themselves with, because it will involve giving up perhaps some ownership interest and some control over the entity as a whole. And that's it.
Great. Thank you, Mark, for a very informative and educational webinar here. Looks like we do have quite a few questions coming in, so I will read through those and give Mark a chance to answer each of those. The first one reads, how does the joint venture have to be organized?
Well, the interesting thing is that there is no particular requirement in terms of how a joint venture has to be structured. A joint venture doesn't have to be its own separate legal entity. You can have an arrangement of two companies that are not separate, that don't create a separate legal entity, and that could be a valid joint venture. Typically, though, especially more recently with some of the things that I've been seeing, is companies are aligning and they're forming this third entity, a separate legal entity, which in the form of an LLC. In other instances, you can have joint venture companies form a separate legal entity in the form of a partnership, and in what I think are rare instances, they'll form a separate legal entity in the form of a corporation. But there's no single structure that's required, and you don't need a separate legal entity at all.
Great, thanks. Next question, when should companies establish the joint venture?
Well, at the earliest possible moment. I think as soon as you begin to see a contract or a task order that might be of interest, I think, at the outset, even before you submit your proposal, I think you should already have your joint venture set up, because again, you have to disclose that the contract will be performed by an entity, this joint venture entity, at the earliest possible moment. And typically that's when you submit your bid. And so it should be as early as possible in the process. And again, because there are work sharing requirements, there are management and control requirements, you want to get all of that hashed out at the earliest possible opportunity, so that when you submit your bid, it's comprehensive, but it's also rational and reasonable within the parties.
Great. What if I have an existing joint venture for a state contract? Can I use that also for a federal contract?
You can. You can use an existing joint venture. The concern there is when typically what I think agencies and contracting offices are used to seeing is they're used to seeing joint ventures that are set up for a very specific contract. And that's the typical kind of arrangement where there's a joint venture, it's under the name of the contract, or it's tied very closely to the contract that the parties are competing for. So that's the typical kind of structure. So when you introduce something that's not typical, I think it creates a little bit of confusion, perhaps. The other issue when you use an existing joint venture that has competed for other kinds of contracts is, again, the rules recognize that a joint venture is going to be for a limited size, of a limited duration, and for a very specific. And what that means is that the rules don't contemplate that a joint venture is an ongoing entity, for an indefinitely ongoing entity. So to the extent that you're using an existing joint venture, you have to be concerned that the agencies might think not a joint venture because it's been going on for longer than we typically see. So you can use an existing joint venture that's already been created, but you have to realize that there will be some issues in terms of whether you are considered a joint venture of a limited duration and for a very specific purpose.
Great. This question may kind of cover some of those same ones. It says, does a joint venture have an expiration date, and is
you don't have to have a specific end date, although, like I said, the rules anticipate that there is going to be an end date. So you have to have an agreement between two parties that include these work sharing requirements, these responsibilities, and what I typically see is joint ventures that are set up specifically to perform a contract, so that once contract has been performed, the closeout, all the way through closeout, that the joint venture agreement will sometimes include a provision that the agreement will, that will put the contracting agency on notice that this is not an arrangement, an indefinite arrangement, and I think that's one way to handle the kind of the time duration aspect of a joint venture agreement. Now, let's say if you're creating an LLC, typically the joint venture agreement is the operating agreement that the LLC partners have created. In a partnership, let's say, if you create a joint venture as a partnership, a separate legal entity, then the joint venture agreement is typically the partnership agreement. If you're creating a corporation, typically the joint venture agreement will be comprised of an agreement among all the shareholders over the bylaws. So when you create a separate legal entity, it's typically the organizing documents that consist of.
Great. Okay. Next question reads, when are the small business revenues combined for purposes of teaming under small business set-asides? Confusing because last example showed combined revenues exceeding small business size standard.
Right. So that's an example. The example I gave was where you have small businesses that exceed the size standard, and they are they're aggregated at the time you submit your proposal. Okay, and at the time at the time you submit your proposal, if you're not eligible for the contract, you will be your bid will be outright rejected. Just to go over those affiliation rules again, you can have businesses that collectively may exceed the size standard for a small business contract. But if it falls within one of these exceptions to affiliation, they can still compete for that small business contract, even though collectively or the number of employees exceed the size standards. But again, the point of the first part of the discussion was about the exceptions to affiliation that allow parties that collectively would not meet the size standard for a contract and still compete for that contract as joint ventures, as long as they comply with one of the exceptions to the affiliation rules.
Great. Are joint ventures and teaming agreements different?
Yes, they are. The joint venture agreements are agreements that will they set out how the businesses are going to perform under the contract, typically. And teaming arrangements typically are arrangements that are set up before parties even, they typically cover how the parties interrelate before the contract is awarded. So, so that in a typical situation, you can have a teaming agreement that sets up, relate to each other as they're putting together a joint venture agreement, as they are deciding what will happen if a contract is awarded. That's where your joint venture agreement kind of picks up.
Okay, great. Women-owned small businesses that we want to work with together on specific projects. What legal form does the attorney recommend?
5 women-owned small businesses. In all honesty, I couldn't probably answer that question with that little information, and that would require a little bit more about what kind of what your goals are, how the parties interact, how they relate. So, I mean, a joint venture is a possible vehicle for you. You know, an arrangement that would be attractive, but it really, you know, as I said before, you have to think about it in terms of how you set these arrangements. Number one, what is the relationship of the parties? Who's, you know, are you comfortable with having one particular business as, quote, the managing entity of this structure? Also, there are tax implications, obviously, profit-sharing implications. You know, how the parties allocate resources. We talked joint ventures that can be populated. That means, you know, they have its own employees. It hires its own employees under its own tax ID, or it can be unpopulated, where the employees are, the work is done by the employees of the separate parties. Well, in that instance, you know, you have to consider, well, do you want this structure to be separately populated? Do you want it to have its own structure? And those issues you got to think about. Well, do you have the resources, the capital, to allocate to a separate legal entity? So there are lots of things that you need to consider in terms of not only just what kind of structure you're going to create for this, whatever it is you're bidding for, but also how much resources you're going to allocate to a particular business structure or entity that's competing for a contract.
Great. Why would joint ventures submit quarterly financial statements to SBA when no other small business has to, unless you have an SBA loan?
Why? That's a good question. I am actually not sure why they have to. Now, as I said, I think, you know, the SBA, you know, there's a concern over protecting the integrity of the SBA, the 8A program. But that's actually a good question. I don't know why other than that there's this concern over making sure that the structure of the business has not changed over time, making sure that you know, to the extent that there's a profit, there's a requirement that the 8A business share in 51% of the profits. Perhaps there's a concern that that might kind of become misaligned at some point, and that these requirements are not going to be met. So I would say that those are probably some of the concerns that the SBA may have.
Right. Is there a minimum amount of work that must be performed by the 8A partner in an 8A joint venture?
The 8A partner, in terms of I think we went over this a little bit, the 8A partner has to do at least 40% of the work for an 8A joint venture. In other words, a joint venture that is competing for an 8A contract. The 8A partner has to do at least 40% of the work if it's an unpopulated joint venture. In other words, if the joint venture entity doesn't have its own employees, then the 8A partner, the employees of the 8A partner have to do at least 40% of the work. If the 8A entity has its own employees, there is obviously no work sharing component because all the work is going to be done by the employees of that particular entity.
Can 8As include more than 2 companies?
They can, which is I think you mean can an 8A joint venture or joint ventures generally? They can include more than one company. So I gave an instance where there were 2 companies that had size standards that were below the small business standard, but you can have 3. Form a joint venture. Again, you have to meet the particular requirements for the and so typically for a small business joint venture, even though you can have 2, 3, or 4 small businesses, again, each business has to be small under the size standard that's set for a small business contract to be eligible for this affiliation exception.
Right. Can 2 large companies form a joint venture?
Yeah, you can have companies that are large, and there's nothing in the rules that prohibit large companies from competing for any contract. In fact, as I said, I think the rules they recognize that the rules recognize this kind of horizontal alignment that can happen. Obviously, if you've got 2 larger companies that can, that have aligned themselves as a joint venture, they're not going to be eligible for some of the small business contracts. But absolutely.
Great. Question about someone trying to understand why these agreements expire at the end of the contract.
Well, the typical scenario, as I said, is a joint venture that's set up for a very particular purpose. And again, you don't have to have an expiration date for in your small business in your joint venture agreement. The concern is, again, the definition of joint venture under the federal rules is very specific, and that is that a joint venture has to be of a limited purpose, a very specific purpose, and for a limited duration. And so, I prefaced my comment earlier, and that was that you don't have to have a specific expiration date. But I think if you know that that this joint venture is only set up for a particular contract, then I think you can ease any concern that that you're part of a serial joint venture. You're part of a serial joint venture arrangement by saying that this particular joint venture is set up for a very particular contract, and that once that contract has been performed and closeout has occurred, that the parties they don't intend to have the joint venture go on. It's not a requirement, but I think what it does is it eases any concern that this joint venture is really not of a limited duration. And I think you'd have to look at the facts and circumstances of the contract that you're competing for. and you have to look at the kind of arrangement you already have to determine whether you want something that's specific. I'm not saying it's required, but I think in certain instances it eliminates any possibility that the parties are engaging in serial contracting.
Great. And that wraps it up. Just to let you guys know, on Wednesday we're doing a webinar on the service-disabled veteran-owned certification. Friday we've got a webinar on social media for marketing and sales. It doesn't really have a government contracting focus. It's open to government contractors as well as commercial companies. Monday will be leverage propel your B2G strategy. And next Friday will be bid protest. In between there, I think we'll be at the OSDBU conference, which I believe is the 25th. Thanks very much to Mark for presenting great information on joint ventures. There's a lot to know, and his contact information is on the screen. So please contact him with any additional follow-on questions, or if you're considering a joint venture, I would certainly recommend his services for that.
Thank you. I really enjoyed being here. And if you have any questions, feel free to call or email. Thank you so much, Jennifer. It's
Great.
enjoyable.
Thanks, Mark, and thanks, everybody.